Thank you everyone for joining this 3PB Family Law Brunch. I'm Matthew Wyard. I'm a barrister at 3PB. You've hopefully all seen what the topics are for today. I will hand over to Jennifer, who's going to talk to you about child deprivation of liberty applications. Jennifer is a barrister here at 3PB. She was called in 2011, before that having spent her life running around the universities of Oxford in England and Harvard in the States. And Jennifer practices with a focus on children and vulnerable adults throughout her work, both in the family court and the court of protection. And interestingly, I know, because I've seen the reported cases, that Jennifer's also been involved in some of the more interesting child medical treatment cases as well. So without further ado, Jennifer, I'll hand over to you.
Thanks, Matt. So it falls to me this morning to talk to you about deprivation of liberty applications for children. And what I'm going to be doing here is really just an introduction to this topic. It's a huge topic, and I just simply can't do it justice properly in the few moments that I have. But hopefully we'll be a little bit wiser about how we are and where we are with this area of the law. Sadly, this area of the law can only be described as a growth area. And if these applications have not come across your desk yet, then they will be coming across your desk. If you are working in care proceedings, and certainly if you're in a local authority, then of course these are things that you'll be dealing with increasing and almost alarming frequency. So what I'm going to be doing here briefly is talking about what a deprivation of liberty is in law, why it's made for children, what it actually means in practical terms for children, which human rights are engaged, how it's achieved legally, how it's achieved practically, and some perspectives on these orders. So what is a deprivation of liberty? Well, we have the STORC components. The first three bullet points in this slide set out the STORC components, and the reference to STORC is in the fourth bullet point. There's the objective component of confinement to a place for a length of time. The subjective component is the second bullet point, that this is the issue of consent. And the third bullet point is that the confinement is imputable to the state. Now, these are really basic principles that have to be considered in every application that is made about a deprivation of liberty. We know from recent cases that have been decided by Mrs. Justice Lieven in particular this year, that she has found in respect of certain applications that these components haven't been made out. So in the case of Peterborough Council and this was a case where she held that the objective component was not met. This was a case that involved a young 12-year-old girl with profound and enduring disabilities. She had no concept of communication, wasn't able to move, was entirely reliant on her carers. And although and she was subject to a care order as well, as when the local authority made an application for a deprivation of liberty order, she said, well, it's difficult to see how one can be deprived of doing something that one is incapable of doing. And she said that this was kind of overkill, that the reason that SM was unable to, well, she wasn't confined, she just wasn't able to leave. She was never going to be able to leave. The confinement was not imputable to the state. The confinement was imputable to her situation, her inherent situation. Another case decided this summer is the case of Jay, where it was held again by Mrs. Justice Lieven that this was about the issue of consent, that the second limb of the STORC components. And in this case, it was about who could validly consent to the confinement. Everyone agreed at the end of the care proceedings that this child, Jay, who was a 14-year-old boy with ADHD and autism, should be residing in the accommodation where he'd been placed. But the local authority felt that it did not have the capacity in law to consent on his behalf. And the judgment of Mrs. Justice Levin was that the local authority did have the capacity to consent on behalf of J, not on behalf of J, but as the parent of J. This, of course, is, you will be aware or may be aware that this has been appealed, and the appeal will be heard in December. But I'm just mentioning this because it's very important that these three bullet points at the top of the slide are made out. So why would children be deprived of their liberty? Well, there's some really excellent work that is being done at the Nuffield Family Justice Observatory, and I can't possibly cover all of that here in this presentation. I would really strongly recommend that you go to their website and see all of the work that they're doing on the research into these types of orders. But in brief, what they say is that these are children who are not unknown to the authorities. They are children who have mental health problems, behavioral and emotional difficulties, and they already have some kind of support, but the support is not adequate for what they need. And often children are associated with or having experiences of early or ongoing childhood adversity, and they very often have very complex trauma as a result of all of that, which influences their behavior. And there is nowhere else for them to go. And the risks that they're facing are immediate and severe. And this means that they have to be deprived of their liberty because it's the only way that they and the people around them can be kept safe. So what does it actually mean to a child when a child's liberty is restricted? Well, this is always a question of continuous supervision and control, that the child is not free to leave. But otherwise, it depends on the child and the situation. And restrictions, in my experience anyway, have included restrictions about food and medication, inspection, even during self-care, restrictions on interacting with others in contact or indirectly through social media or mobile phone, restrictions on use of the internet, gaming, television, other hobbies, and there's a permissive sanctioning of restraint techniques when required. So how does this relate to human rights? Well, I'm going to break this up into two sections, Article 2 and 3, and then Article 5 and 8. But in respect of Article 2, the fact that everyone's life shall be protected by law, this has been interpreted to include the positive obligation of the state to ensure that preventive measures are taken to protect its citizens. This includes children. And this also has been interpreted as the state's being required to take appropriate steps to safeguard the lives of those within their jurisdiction. So there's the safeguarding element, which is sort of understood to be part of Article 2. In Article 3, which is a right, which is an absolute right, is that no one shall be subjected to torture or to inhuman or degrading treatment. And that has been interpreted as including serious physical violence or psychological abuse, humiliation of an individual that arouses fear or demonstrates a lack of respect for their human dignity. And this can happen with children who run away, they go missing, they're groomed into exploitation, either sexual or criminal. And this kind of inhuman and degrading treatment with the state is required to protect and prevent its citizens and indeed children from experiencing. Article 5 is kind of almost where the action is, in the sense that this is specifically the article that deals with the right to liberty. And it says that everyone has the right to liberty and security of person, but there are exceptions. And one of the exceptions is the detention of a minor by lawful order for the purpose of educational supervision. And another one is the lawful, forgive me for the typo there, lawful detention of persons of unsound mind. So the lawful detention of persons of unsound mind, that I will get to a little bit later. That is about, well, that can be about Mental Health Act detentions, which I'm not going to be discussing here. But it also can cover 16 and 17-year-olds under the Mental Capacity Act, who would be sort of covered in the Court of Protection. And this is because the Mental Capacity Act includes that a person has a mental disorder. But for here right now, I want to talk about the detention of a minor by lawful order for the purpose of educational supervision. Now, educational supervision sounds very far away from what I was describing earlier in terms of how practically the liberty of a child is restricted. But in the jurisprudence, educational supervision has been ascribed a broad meaning by the courts. It covers the general development of a child's physical, intellectual, emotional, social, and behavioral abilities. So a court will have to decide on the evidence, which will include a detailed care plan for a child, whether this educational supervision component is satisfied. Article 8, we all know Article 8. I'm including it because it's something that also comes to play, but also it just reminding us about the fact about the case of Ribi, which we also all know, and to remind us that these human rights can only really be interfered with when it's necessary and proportionate to do so. So we do have a statutory framework for depriving children of their liberty, and it's called secure accommodation orders. And this is Section 29 of the Children Act. And I've just set out here, I'm sure you are aware of when these secure accommodation orders can be made. They are actually for the purpose of restricting liberty. They are for children that are in care who have history of absconding and are likely to abscond, and during the period of absconding, they're likely to suffer significant harm, or if they are accommodated in any other kind of accommodation, they are likely to hurt themselves or other people. So we have that already. So why don't we just stick with secure accommodation orders? Well, on this slide, I have said that there's an insufficient provision of secure accommodation to make those Section 25 orders. But orally, I'm going to say that it is the provision is woefully inadequate. I was looking at the Department of Education statistics as of March 31st this year. There are 14 homes in the country. There are 157 places that are available currently. And there are 59 children that are being accommodated in those placements by the Youth Custody Service. And so this leaves less than 100 places available nationally to local authorities to accommodate children who require that kind of accommodation. So the DOLS orders are kind of workaround. They are court-sanctioned placements of children in unregistered placements. And we can see from the Nuffield Family Justice Observatory work that there has been a nearly 1,300% increase in DOLS applications between the 6-year period of 2017 to 2023. And in fact, now we have a national DOLS list at the RCJ. So how does it work, really? Well, the way it works is that it's possible in law to use the inherent jurisdiction to make these orders. And this was confirmed in a case called Riti, which was heard at the Supreme Court in 2021. And the issue was about a 15-year-old girl who actually, by the time it got to the Supreme Court, she had already aged out of the system. But the question was whether that what should happen when the local authority says that a Section 25 secure accommodation order is warranted, but is proposing that the child is accommodated elsewhere than in a secure home, and whether the child's consent is relevant. And the problem, of course, in these cases is that it's actually a criminal offense to manage an unregistered children's home. And that's a criminal offense under Section 11 of the Care Standards Act. So what was held by the Supreme Court in 2021 was that DOLS was going to be a kind of the invocation of the inherent jurisdiction and the use of it to sanction these placements was seen as very much as a temporary solution to be deployed in exceptional circumstances. Later that year, there was a case in the Court of Appeal going into more detail about the use of inherent jurisdiction. And it's quite interesting. I mean, that's a very interesting case anyway, but it's quite an interesting observation that the president makes here. He says that we found that the scheme does not allow unregistered placements, right? This is the Children Act, doesn't allow unregistered placements. This is Section 22C, but it doesn't expressly prohibit them either. And what I say is in that space between not being allowed but not being expressly prohibited, that's where the inherent jurisdiction is invoked. And now we have, now by the last count, I think 1,700 of these applications being made a year. So how is a child deprived of his or her liberty? Well, an application has to be made by a local authority on Court Form C66, and it has to be sent to the National Dolls List, which is in the Royal Courts of Justice, and it has to include a statement from a social worker. And the statement has to include the background of the case, details of the placement, involvement of the child with other services, including CAMS or any other kinds of services that would be, that the child has been involved in. There has to be something about educational arrangements for the child, arrangements for contact, and details of any related proceedings. So oftentimes these are cases where children are already in care, or already in care proceedings, forgive me, but sometimes this actually, it's the DOLS application, which then can prompt the care proceedings. So it may be that local authorities are intending to issue and haven't yet issued, or that they have already issued. The judge will have to decide at a hearing whether the arrangements are indeed a deprivation of liberty and whether the restrictions are necessary and proportionate. That's basically what it comes down to. Orders can be made up for up to 12 months, but in practice they're shorter. One thing to mention is that the expectation normally is that following the initial hearing, the proceedings would then be transferred to a child's local court, and there is going to be, or there either will be, or there already are, parallel public law proceedings, and that will allow for judicial continuity. And this only really works if there's a Section 9 judge who's able to deal with the matter locally. So the local authority is going to have to let the National Dolls judge know if there is local court suitability. It's important also to note that if this is a standalone hearing, in other words, not as an extension of care proceedings, there isn't any non-means legal aid available for parents and children. So what do judges make of this? Well, judges really don't like the fact that there's not enough secure accommodation. Lord Stevens in RET echoed a previous comment by President Munby, as he then was, that the situation is disgraceful and utterly shaming in respect of secure accommodation for children. A few years later, Sir Andrew Macfarlane slightly takes a softer approach. He just says, well, it's not the role for the courts to provide accommodation. And all the court can do is just call the problem out and shout as loud as it can and hope that somebody will listen. The president's guidance has been revised. There had been guidance that was originally published in 2019, and that was very activist. There were all sorts of things that had to happen in respect of trying to get these placements registered, and there were requirements in terms of notifying. The local authority had to notify either Ofsted or Children in Wales, and then there had to be follow-up hearings about the process of becoming regulated. But now, after these cases have become so commonplace and so standard, unfortunately, the tone of the president has really changed. I mean, he wrote the guidance in 2019, and he's written the guidance again in 2023. And he's reminded judges that it's not for the court to become a regulatory body or oversee the regulatory process. The role is simply to consider the applications, exercise the inherent jurisdiction, and ensure that the deprivation of liberty is not unlawful. He further sets out in the guidance that it is possible, the courts should inquire whether the proposed placement is registered or unregistered, and it should ask local authorities to consider why they say that an unregistered placement is in the best interest of the child. But all of the previous guidance in terms of contacting Ofsted and Children in Wales, that's now just something that a court might order the local authority to do, but it doesn't have to. We've moved from activism to weary acceptance in respect of this area of the law. It's possible to transfer certain of these cases to the Court of Protection, and this is where there are young people aged 16 to 17 who lack capacity to make decisions about their care arrangements, and also where it's likely that they will be transferred to the Court of Protection when they turn 18. And this is quite easily done. You can see in Section 21 of the Mental Capacity Act 2005 how to do this. And you can also just check out the Code of Guided Practice of the Mental Capacity Act, Chapter 12. Many of these placements are increasingly in Scotland, and so local authorities need to be aware that there are actually regulations about how children in England can be placed in Scotland under deprivation of liberty orders. And there is a similar order in Scotland called a compulsory supervision order. If a local authority is going to place a child or a person, P, in Scotland, the placing authority has to give notice and give an undertaking to fund that placement to the institutions set out in the regulations before the child is placed in Scotland. So please be aware of the regulations and the requirements of those regulations before you move a child to Scotland. And it's very easy to find the regulations. It's just on the Scottish Government website. So I've tried to set out an introduction. I've tried to set out the law, why we have the situation that we have, where we are currently. I've tried to explain that there is some interplay between COP and the Children Act in terms of how these children can be deprived of their liberty. It can be in either one of those jurisdictions. But one of the things that I haven't talked about, and often we do forget as practitioners, is the views of the children themselves. And I just want to, it's not a legal point, but it would be useful for all of us who deal with this area of the law to listen for 45 minutes to the File on 4 program on BBC called Detained and Restrained, which actually talks to children about what it was like for them to be deprived of their liberty. And in July 2024, the Nuffield Family of Justice Observatory has also published sort of a document, but also has recordings of caregivers' voices called "This Is What We Think," and this also includes children that have been deprived of their liberty. In the BBC file M4, there are different views, not just of children. A judge says, it's not infrequent for judges just to be given one option and told this is the only arrangement we can make, and the judge feels compelled to make the order. A young person who is no longer on a deprivation of liberty order, and now indeed is in his 20s, says, I'm still stressed out. I've become an extremely paranoid person because of the supervisions. Even when I don't do anything wrong nowadays, I'm scared that someone is going to take me away. And although I've talked about a judicial view and a specific child's view, I think it's best to close this presentation by considering the view of the Children Commissioner, because she really raises a question just about how these orders actually affect all of us. She says, if you're going to deprive a child of their liberty, you're talking about the most vulnerable children in our country, and how we treat these most vulnerable is a sign of what we think about childhood. I'll stop there. Thank you so much for listening.
Thanks, Jennifer.
I'm now going to have I have the privilege of introducing my colleague, Matthew Wyard. He's 2014 call. He is a public and regulatory lawyer and is involved in cases that span many things, education, health, social care, and COP. He is a very practiced writer. He contributes to the Education Law Handbook, to Lexis, PSL, and Practical Law. And he's also a JR expert and has covered an enormous range of topics that he has advised the government on.
Thanks, Jennifer. Morning, everyone. So I'm going to talk to you a little bit about something that might be quite unusual to some of you. Safeguarding adults, both in the Court of Protection and in the Family Division. I say it's perhaps slightly unusual because it's not really, I suppose, family law. So the first thing I want to address is, well, why should you care? Because it's probably a fair question. Why, as family lawyers, should we care less about protecting vulnerable adults when we spend our lives dealing with children? And I would say there are 4 reasons. Firstly, you can offer a more holistic service. If you think about it as a solicitor, if your clients are children or the parents of children, those individuals probably don't just have children, they also have parents, aunties, uncles. You can put yourself out there as offering a holistic service to the whole family if you can deal both with their children problems and their adults. The second reason is the Court of Protection work is a huge growth area. When I started 10 years ago, there were very few COP cases, and the reason I fell into doing it was because I had a community care practice, and you often found at the time that a lot of the Court of Protection work was dealt with by community care practitioners. Nowadays, it's very much an area in itself, and there is an enormous growth of instructions in the area. Funnily enough, a lot of family lawyers are taking an interest, and that's probably because of the last 2 points. So as family lawyers, you will have transferable skills that allow you to get to grips with court protection work fairly easily. The big one is the soft skills. You can learn the legal stuff, and we'll talk about the legal side of it shortly. What you can't learn so easily is how to actually speak to people, how to gain their trust, which you need to do in COP, just like you do in family law, potentially in ways that you don't in other less emotionally charged areas of law. Point number 4 is that if you've got an interest in the law, then you'll like COP. Jennifer and I did a podcast, I run a court protection podcast that Jennifer came on to speak about. When I asked Jennifer how she got into court of protection work, she said, "Well, I really enjoyed the law and I was missing it doing family law." And that's not to say there's no law in family law, but there is certainly a lot more black letter law that you have to deal with regularly in court of protection, as I understand it, than there is in family law. So if you're a family lawyer wanting to offer a more holistic service in a growing area, you like dealing with people and you like law, court of protection is probably an area that you would enjoy. How then do we go about protecting vulnerable adults? Well, there are various options available. As with children, you can raise safeguarding complaints with a local authority, albeit it's done under the auspices of the Care Act 2014 rather than the Children Act. And if you're really worried, you can contact the police, and they've got various powers that allow them to protect adults as they do children. But broadly speaking, the two key court-based processes that you need to know about are those in the Court of Protection and under the inherent jurisdiction in the Family Division of the High Court. The key consideration when choosing which of these avenues to go down to protect a vulnerable adult is the statutory threshold. I say threshold deliberately because what I'm going to try to do throughout this talk is draw your attention to where family law and these areas combine. So there is a threshold, as I understand it, in care proceedings, as there is in court of protection proceedings. You can only go to the court of protection where the person you're seeking to protect lacks the mental capacity to protect themselves effectively, to make the decision that needs to be made in order to resolve the situation they're in. If they lack the mental capacity to do so, you can go to the court of protection. If they have the mental capacity to make the decision, but for some other reason aren't able to make it, and we'll explore what those other reasons are shortly, then you might think about going to the Family Division of the High Court and inviting the court to use its inherent jurisdiction to protect the adults. We'll now turn to look at both of those options in a bit more detail. And we'll start with the Court of Protection, or COP as it's more commonly known. What is the COP? Well, it's a superior court of record and has broadly the same powers as the High Court, and it has really three key functions. Determining questions around someone's mental capacity, so determining if they do have mental capacity to make specific decisions at all. Secondly, if they lack that capacity, making decisions for them that they can't make for themselves at the relevant time. Or thirdly, appointing people to make decisions on behalf of others. Some of you may have others in your firm who act as professional deputies on behalf of clients who lack capacity. Now, admittedly, that all sounds quite vague. What are the actual kinds of scenarios that crop up in the COP? Well, there are broadly two streams of cases: those that deal with an individual's property and affairs, and those that deal with their health and welfare. So under the property and affairs stream, you can deal with things such as whether someone can manage their own property and finances at all. You can have decisions made about whether someone can buy or sell a property, if someone can continue to carry out a contract that they've entered into, or even execute a will. We'll perhaps leave that to the private client lawyers. The area that's probably of more interest is the health and welfare jurisdiction, and that deals with things that are probably familiar to some of you. So where people should live, who people should have contact with, what kind of medical treatment someone should have, if any, whether someone can have sex with another person, whether someone can access social media or the internet, any aspect of one's health and welfare that you can think of can come under really the jurisdiction of the COP. Probably I was trying to prepare the talk, was trying to think of the three most common kinds of cases you're likely to come up with when you first start out in this area of work. Broadly, I think you're likely to come up with one, the deprivation of liberty challenges. So Jennifer has spoken to you about DOLS applications in relation to children. By far the biggest area of work in the Court of Protection are Section 21A DOLS applications in relation to vulnerable adults. And that's typically where someone lives in a care home or a hospital and they want to leave. And the court looks at the situation and decides whether someone should remain in the care home that they're in or whether they should move to a different one. The other two areas, contact and residence disputes, and they commonly crop up in situations where perhaps a child has been removed from their parents as a child and placed into care. As soon as they hit 18, if they are disabled children, it's not uncommon for parents to try to regain contact or perhaps to have those children move back in with them. And you can have disputes over whether that is in a child's best interest or at that point an adult's best interest. And then if you're more interested in the property and finance side of things, you're likely to come up fairly regularly against contested deputyship applications. So that's where someone decides that their relative lacks capacity to manage their property and affairs. They apply to the court to be appointed a deputy in order to manage their relative's affairs for them. And someone else in the family says, no, 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 you can't be trusted, or for whatever reason, we don't want you to be appointed deputy. We think it should be us, or we think it should be brother or sister. So those are the three most common kinds of case you'll find in the COP. And you can hopefully start to see that there are similarities between the work that you do as a family lawyer, residence, contact, best interests, welfare, that are probably quite nice crossovers. And I thought the way to really put that into perspective is to look at some of the fundamental principles in the Court of Protection as well. Some of them won't be so familiar, but some of them will be familiar to you. The key principle then is mental capacity. And mental capacity is, in a nutshell, one's ability to make a decision. However, it's the ability to make a specific decision at a specific time. And as you can see from the slide, there is a case, CC and KK from 2012, that considers capacity as a whole and determines that it is time, issue, and decision specific. So what that means in practice is that when you look at someone who may lack capacity, it's not a black and white question. It's not they lack capacity or they don't. It's in relation to a specific decision. So does P, as they're called in the Court of Protection, have capacity to have contact with X or Y? Could lead to a very different answer to whether someone has capacity to live with X or Y. And equally, capacity can fluctuate. So someone might wake up with capacity to make decisions to use the internet. They might have their lunch and then lose capacity after lunch, and they might regain it in the evening. And it's actually really common with people with dementia for this to happen because there's a concept of sunsetting where their capacity fluctuates throughout the day and they become more lucid at certain times of the day. When we talk about someone lacking capacity, we mean that they're unable to make the specific decision that needs to be made at the specific time it needs to be made because of an impairment or disturbance in the functioning of the mind or the brain. And that language and terminology is important and is something we're going to come back to. Now, if you are thinking about embarking on learning law around this and starting up a court of protection practice, I certainly recommend it. There's not that much comparatively to some areas law to learn, but there is some stuff you need to know fairly quickly. The best place to start is the Mental Capacity Act 2005, Section 1. What Section 1 does is set out various principles that underpin everything that is done in the Court of Protection. So the first fundamental principle is the one at Section 1, subsection 2. There is a statutory presumption, albeit a rebuttable presumption, in favour of capacity. So if you have an individual and you want to restrict their contact with someone, the question is whether they have capacity to make that decision themselves. The starting point is that they do, unless you can put some evidence forward to cast doubt on that. The second point, that when you first start this work, it's quite difficult to get your head around, is that Section 1, subsection 3, which is that subsection 4, sorry, which is that a person is not to be treated as lacking capacity simply because they make an unwise decision. So in other words, as capacious individuals, we all have a right to do effectively whatever we want. We've all got personal autonomy. No one can stop us from making an unwise decision. And there is no one legally who can stop me from going to a casino tonight and gambling all my money away. There's no one who can stop me if I get an email from someone pretending to be I don't know, a princess needing help and wanting £100,000. There's no one who can stop me from sending my money into the ether if I want to. And that's the same with someone when you're judging their capacity. Just because someone is making an unwise decision, that does not of itself lead to their lacking of capacity. Interesting example of that using the online romance scam example that I alluded to just now. That does happen. And when it does happen, it happens in a big way. I had a case in Wales a couple of years ago about an elderly gentleman who was in his 70s, and he had really fallen victim to a love scam. He'd been emailed by someone pretending to be his girlfriend. He didn't have capacity to really know much of what was going on. He'd engaged in emails online with this person, sent a significant amount of his money to this individual abroad. He'd also fallen into the trap of effectively committing money laundering. He'd opened up a bank account that someone had transferred money to. He'd then gone into the bank and sent it back. So there was question marks there over whether he truly knew what he was doing or whether he lacked capacity. Now, the other big concept is that of best interests. So whenever a decision is made for anyone who lacks capacity or under the Mental Capacity Act at all, that decision must be taken in their best interests. It's not the same as welfare interests for children, but it's not too dissimilar. There isn't a court of protection. It's not formally called this, but there is a best interests checklist, effectively. So when you're looking at Section 4 of the Mental Capacity Act, where you might find what you could call the best interests checklist, you have to make a decision based on the hierarchy of all the principles therein. It's not hierarchy, actually, but there are a number of principles that you need to have regard to. So you can't make a decision based on someone's age or appearance or on justified assumptions about what might be in their best interests. You must take account of their past and present wishes and feelings. You have to take account of any beliefs and values that would have influenced the decision were they to have had capacity at that time. You have to take into account any other factors that the relevant person might have considered, and you have to take into account the views of various people. Now, that's not too dissimilar, I don't think, although Jennifer, you can come in at the end and tell me I'm wrong about this. It's not too dissimilar to the welfare checklist when we think about children, albeit it is applied in a slightly different way. But what then is the test for whether someone has capacity? Really, there are three elements. There's a diagnostic test at Section 2 of the Mental Capacity Act, the functional test at Section 3 of the Mental Capacity Act, and then the common law principle that arises from a case called PC and NC in the City of York Council, which is that there is, in interpreting the Mental Capacity Act, a causative link between the two. So in effect, the mental impairments and the inability to make a decision must be linked. But let's bring that to life and actually look at what I mean by the diagnostic and functional test. So the diagnostic test is really the medical, the clinical side of it. So where someone is unable to make a decision, is the reason they're unable to make a decision because of an impairment of or a disturbance in the functioning of their mind or brain. And that's a matter of fact that the court has to determine on expert evidence before it. There are various ways that that evidence is provided. Sometimes it's relatively straightforward and you can put in place a GP summary or medical records. But more commonly, you'll have expert reports prepared under Section 49 of the Mental Capacity Act that give that evidence. But interestingly, you do not need a formal diagnosis. So if you can show that someone is unable to make a decision because of how their mind or brain functions, but they don't actually have a formal diagnosis to back that up, someone can still meet the diagnostic test. I mean, it's not that common, but it can happen. And there's an example on the slide of a case involving Birmingham NHS Foundation Trust, where someone had effectively been admitted into hospital for so long that it had impaired their thinking to the point that they were found to lack capacity. The functional test is really where most capacity disputes are determined in the Court of Protection. So Section 3 of the Mental Capacity Act sets out what the functional test is. It's not quoted directly on the slide, but broadly there are 4 aspects to it. The relevant individual must be able to understand the relevant information in relation to every decision that they have to make. They have to be able to retain that relevant information. They have to be able to use and weigh up that information, and then they have to be able to communicate a decision by any means possible. Each domain of capacity, if you think about what I said earlier, things like residence, contact, care and support, internet use, managing your property and affairs. What's interesting is that each of those domains are treated differently. And that's where really the law comes into it, because there is an awful lot of case law that you do need to get to grips with that outline what the relevant information in relation to each of those domains of capacity are. And it makes sense when you think about it, because if you are deciding where you want to live, you're thinking about very different things to the risks that you're thinking about when you decide if you want to use social media. And that's reflected in the practical functional test under the Mental Capacity Act, in that the relevant information for each decision is different. But as I say, P, as we call the relevant person in court proceedings, needs to be able to understand the relevant information specific to the decision that they want to make, retain it, although they don't need to be able to retain it for very long. It depends on the decision that needs to be made. They need to be able to use or weigh up the information and then communicate it. And that communication point is an interesting one, because as capacious individuals, particularly as lawyers, we're used to communicating in writing and verbally. For obvious reasons, not everyone who's involved in court proceedings can do that, and there's no reason necessarily why they need to be able to do so. I've had cases where people communicate through eye signals and eye gaze technology, but equally I've heard of cases where people communicate through squeezing a partner's hand, things like that. They can acknowledge and make decisions and communicate them through that kind of mechanism. Now, when you're looking at this test, what's important to bear in mind is that only one of the limbs needs to be missing in order for someone to lack capacity. Now, usually you will find that it's the ability to understand the relevant information or to weigh up the relevant information that's lacking in someone who's incapacious. They can often retain information and they can often communicate a decision, but it goes to the ability of them to actually analyse the information that's important. So that is broadly what I wanted to say on the Court of Protection. So I've explained to you why it's relevant to your practice. I think you've probably got the idea now that I think you should all go and have a go at this, because it is an interesting area of law, and I've given you some knowledge about the basic principles. Obviously, you'll need to read around the area in order to start out in your first case. As I say, look at the Mental Capacity Act 2005, look at some of the case law, look at something called the Blue Book, which is the Court of Protection practice. It's the COP equivalent of the Red Book in family law. But now what I want to move to talk about is the inherent jurisdiction in the family division of the High Court. And you'll remember from one of the first slides, the key distinction between the inherent jurisdiction and the COP is that if you're exercising the inherent jurisdiction of the High Court, it's because the person has the mental capacity to make the decision. Now, I suspect you'll all be familiar with the case of Riel. That is the case that effectively considered a single point of law, which was whether, following the implementation of the Mental Capacity Act, the inherent jurisdiction was still an available option for protecting a vulnerable adult who lacked or who had capacity. And the answer from the Court of Appeal was a resounding yes, it's still available and should be being used in the correct circumstances. Now, just because an adult has capacity doesn't mean that they are eligible For proceedings under the inherent jurisdiction, they need to be vulnerable. What do we mean by vulnerable? Well, that was considered by Mr. Justice Mumby, who I think at the time was the president of the family division in a case called Re-SA. That case gives 3 examples as a non-exhaustive list of when someone will be considered vulnerable for the purposes of exercising the inherent jurisdiction. Firstly, when they are under constraint. Secondly, whether they are subject to coercion or undue influence. Or thirdly, for some other reason, they're deprived of their capacity to make the relevant decision or disabled from making a free choice. How does that come across in practice? I'll give you an example of a case I did recently. Elderly lady had capacity. She lived at home in a property that she owned with her son. For the purpose of this talk, we'll call him Ben. The little old lady, we'll call her Jean. Jean lived at home. She had a package of care provided by her local authority, which involved carers going into her home every day to look after her because she couldn't meet her basic care needs. Ben had fallen out with one of the carers. So what he took to doing whenever the care staff came to the property was opening the door, telling them in not so nice language to go away, and refusing them access to his mother's property in order to meet her care needs. My client, the local authority, understandably became quite concerned about this because if the care staff aren't meeting mother's care needs, we have no real evidence at all that the mother's care needs are being met. We had a fairly good indication that mother wanted those care needs to be met because she'd engaged with a care assessment in the first place. So the local authority questioned what they could do to protect Jean from Ben, effectively. And we went through the test in Re-SA and considered whether she was under constraint, subject to coercion or undue influence, or for some other reason was deprived of their capacity to make a decision. And we decided that the third limb of that test was probably met. She wanted care and she was being prevented from having it because the carers were being prevented from accessing the home. So the first limb was met. We then had to consider the case of Riel again, because what Riel also says is what the test is for determining whether or not the court will intervene in cases involving vulnerable adults. And it's a similar test to that which you might consider if you're doing a Human Rights Act challenge under Article 8, whether the proposed intervention is necessary and proportionate. So for that to be met, you need to have a plan of action to protect the vulnerable adult. It is necessary. You have to show it's necessary to protect them, but it's also really the least restrictive way of doing so. And in that case, unfortunately, whilst the social workers had done a good job of spotting the issue, what they'd not thought about by the time the case came to me was what we were going to do. It made for quite an awkward conference when I said, well, yeah, I think they probably do meet the test in SA, but what are you proposing? How are we going to address this? How are we going to get access to the property? And the social work staff looked blankly back at me, having not thought about it. So you need to think about that. But what is the court's approach to these situations generally? So if you make an application, what the court tends to try to do is exercise the inherent jurisdiction to facilitate the process of basically unencumbered decision making. So it will take the least restrictive step available in order to ensure that the vulnerable adult can make their own decision. It tends to not try to make the decision for them, which is another distinction with the COP, where the COP will make a decision for someone if they lack capacity to do it. Now, that being said, you can get long-term injunctive relief if you think it's necessary and proportionate to do so. I've given you an example now of the kind of situation in which you could use the inherent jurisdiction. Other areas that I've seen it used in are where there's domestic violence going on at home. But in terms of the kind of evidence that you might need to obtain if you're thinking about this kind of process, you need to get capacity evidence because you need to show, if you're going to the inherent jurisdiction, that P has capacity. Because if not, then the court will tell you to go to the COP. You can do that through a capacity assessment if possible. but often the local authority can help you do that because they will have often undertaken capacity assessments. You also need evidence of a situation that is actually capable of being addressed by the court in its inherent jurisdiction. That's typically your witness statement evidence. It can also be evidence from third parties about what's been going on. Perhaps you've got safeguarding investigations. You do, which is slightly dissimilar as I understand it from pure family law, need to show that you've tried to avoid going to court in the first place. There is a need for a basic pre-action process. It's helpful because often it can resolve things at the outset. And then lastly, you need to determine the actual practical steps that you're going to ask the court to take to resolve the situation. So that, within the allotted time, is a very, very brief overview of the court protection process for family lawyers, as well as the way to protect vulnerable adults in the family division.
So thank you very much. And if you have questions, please do let us know, and we'll close the session now. Thank you.
Thanks, Jennifer. Thanks, everyone.